Hello, welcome to our annual fall conference. I'm Sean O'Connor, Faculty Director of the Center for Intellectual Property by Innovation Policy, or C-IP2, or as we pronounce it, CIP2. We're really excited to have our first annual fall conference under our new name, under the rebranding and the new mission that we have. Some of you may well remember us under the former name of Center for the Protection of Intellectual Property. And if you want more information on our rebranding and how we've changed things a bit, please look at our website, which is available through the, we can put it in the link, although many of you already know what the website is. We're really thrilled to do our annual fall conference on artificial intelligence and intellectual property. It's an area that we have been monitoring for a number of years. For some time, there was almost too much focus on the down the road authorship, inventorship, and thinking about AI as kind of sentient beings. And it seemed like there was a lot more sort of metaphysics and futuristic stuff going on, which is fun to contemplate. But we wanted to wait and do an IP conference when there was stuff on the ground happening that really was being used today by technologists and creators. And we think we are at that point now. And so we thought it was time to do a conference on artificial intelligence and intellectual property. It's also a good topic because it allows us to showcase the three areas that we cover at CIP2. One is high-tech, information technology kind of space, both hardware and software. The other is biopharma, biotech and biopharmaceuticals. And then the third is creative industries. And AI certainly is playing out in all of those places. Now, we will, of course, cover the exciting area of thinking about authorship and inventorship. And we have Professor Ryan Abbott, who is going to lead us off with an overview of his work and looking in particular at some of the work he's done with the DABUS patents to try to get an AI engine actually listed as the inventor of record on patents. We then will close the conference at the end with a very interesting fireside chat that I'll moderate with Jaron Lanier, the major technologist that many of you know about, and Grimes, the musician who has used AI quite a bit in her work. And we think that's just going to be great end and beginning to this. And then in between that, we'll have all sorts of great sessions looking at different angles of artificial intelligence and IP, again, through the lens of the three major areas that we cover. Now, I want to turn it over to Joshua Kresh, who is the managing director of CIP2, and he will go through a little more detail on what we'll be doing for the next day and a half, or I guess a half day and then a day. And he'll also talk about some sort of housekeeping things, what to keep in mind as we're going through. And yes, unfortunately, we are on Zoom, only online again, but we do hope in the coming year to be back in person. At the same time, we're happy that we can pull off these events anyway, even with having to be online. So with that, now I'll turn it over to Joshua Kresh.
Thanks, John. I want to start by thanking our sponsors, and our sustaining sponsors are AAP, the American Association of American Publishers, Biotechnology Innovation Organization, Copyright Alliance, Disney, Ericsson, Motion Picture Association, MPEG LA, Nokia, Pharma, Qualcomm, Relics, RIAA, and AbbVie. At the gold level, we have Johnson & Johnson, Kirkland & Ellis, Oblon, again RIAA, and Stern Kessler. Silver level, Google, Jenner & Block, SAG-AFTRA. And value support, the Authors Guild, Barnes & Thornburg, Hogg Partners, Jones Robb, and Millen White Solano and Brannigan PC. Some of those sponsors will be sending around one-page materials, which will circulate with emails that will follow later. Please take a look. Then, in terms of housekeeping, CLE, as with most of you are familiar who've done virtual CLE, to keep track of attendance, we will be giving out CLE codes during each session. The codes will be said once or twice. You will need those codes to get CLE. So if you don't get the code written down, you can watch when we release the sessions later for streaming, but you can't just email us and ask for the code. And we can't, help if you don't hear the code. You'll have to rewatch, or at least, find the segments where it is and watch that. And with that note, I'll turn it over to Ryan Abbott for our opening keynote. as Sean said, Ryan has been heavily involved in trying test case for AI as the inventor in patent applications, and has a book which you can talk a little bit about, which is connected to the conference. And with that, I'll stop talking.
Well, thank you, Joss and Sean, and it's a real pleasure to be here speaking with all of you today. It's unfortunate that we aren't in person, but it's fortunate that I'm going before and not after Grimes. It is hard to compete with just about anything as a patent attorney giving a talk about IP, but particularly Grimes would have been troublesome, but I'll do my best. I'd like to start with some ancient history in the world of artificial intelligence, and this is a picture from a 3-game match in 2017 in which a DeepMind AI called AlphaGo and the world's best human Go player, Ke competed, and the AI won. And it was interesting for a number of reasons, but one of the things I found most interesting about this was that Go was the last traditional board game at which people could outcompete machines. There's now an entire field of human activity at which AI can dramatically complete tasks better than people. Now, board games aren't the most socially important field of human activity we have, but Google didn't buy DeepMind so it could dominate the competitive Go market. And indeed, DeepMind started turning toward more practical endeavors after Go, including having AI predict how proteins fold in 3 dimensions based on their 2-dimensional amino acid sequences. And at the end of last year, the company was again in the news, this time announcing that its AI had substantially outperformed other teams in an annual contest aimed at predicting protein folding structure. That sounds like a mighty boring contest, but unlike Go, predicting protein folding structure can be a critical element of research and development, for example, in drug discovery, if you are designing new antibodies to target proteins, or to improve our understanding of diseases like Alzheimer's that involve protein misfolding. DeepMind most recently used its AI to predict the molecular structure of hundreds of thousands of proteins, including almost all of those in the human body, and it published those results in an open access database. AI isn't just playing games and doing research, it's doing a lot, and a lot of basic activities we might not think too much about, and a lot of sorts of things that only people used to do, from basic stuff like operating a cash register to somewhat more complex stuff like driving. Sometimes doing that fairly well and sometimes not, but hopefully in the not too distant future, doing it better than we do. And the bar for driving as well as a person is pretty low in some ways. About 94% of all motor vehicle accidents are caused by human error, which ends up killing more than 1 million people a year worldwide and more than 30,000 people a year in the United States. If AI could outperform us at driving the way it does at board games, that could really improve things for us. And AI isn't just automating tasks we think about as routine. It's doing tasks that highly skilled professionals do, like lawyers and doctors. The US Food and Drug Administration has already approved AIs that autonomously diagnose certain conditions, like this device that diagnoses diabetic retinopathy and macular edema. These aren't decision aids for human physicians to refer to. They replace what it is that a human physician does, and they practice medicine, at least in a very limited sense. All of this, robot doctors, robot drivers, are scary to people, but exciting to other people. And before you get too scared about robot doctors, if you think that people are bad drivers, far more people die every year from medical error than from motor vehicle accidents. So there's definitely some low-hanging fruit to be had in this space. None of this has escaped the attention of policymakers. A few weeks ago, the most recent national AI strategy came out from the UK government. It contains a 10-year plan to make Britain a global AI superpower now that we are living in, quote, the age of AI. It focuses on investment and planning, supporting the transition to an AI-enabled economy, and assuring appropriate governance frameworks. And if you think it's just contributing to an overall global economy, to give credit where credit's due, AI did more or less make this particular PowerPoint. At least it figured out a design I liked with the graphic. It kind of fell short when I started trying to paste quotes. It couldn't figure out a design, but I think it was just ahead of me because none of you really wanted to read quotes on a slide anyway. This latest industrial strategy didn't make quite the splash as some earlier ones have. China released their AI strategy in 2017, which planted a flag in the ground with the ambition of China becoming the world leader in AI by 2030, to make AI a $30 billion a year domestic Chinese industry, and to make China a driving force for ethical norms and standards around the world. A couple of months after that, Russian President Vladimir Putin famously declared, "Whoever becomes the leader in this sphere will become the ruler of the world." And at least someone is taking this seriously. According to the US National Security Commission on AI, which was formed in 2018 and which just published its report this March, China is winning the AI arms race, or at least the US is falling behind. It's a 750-page report, but the gist is that the US is not sufficiently prepared to defend or compete against China in the AI era. It proposes that we up our spending on non-defense AI R&D to $2 billion next year, all the way up to $32 billion a year in 2026, similar to what we're spending now on biomedical research. This report also has a chapter in IP and its importance for not just industrial strategy, but even national defense, along with some of the important issues that need to be addressed for the US to be successful at using and promoting artificial intelligence, including my personal favorite, inventorship by artificial intelligence, but we'll get there. Different jurisdictions aren't just competing in terms of technology and investment. They're also competing, or maybe collaborating, with governance frameworks for artificial intelligence. Having good laws in place is not only a critical component of industrial strategy and economic competitiveness. More broadly, it's vital to ensuring that technologies like AI are created and used in ways that promote social value and that limit harm. All technologies and activities can cause harm, and AI is no exception. AI has been used for political and social manipulation. It has caused flash crashes in the stock market, and some fairly prominent technologists think it may doom the human race. The European Commission proposal doesn't quite get into dooming the human race, but it does set out a risk-based approach that completely prohibits certain uses of AI, for example, involving indiscriminate facial recognition in public places, although there are some exceptions, or to generate social scores of citizens. It proposes a variety of compliance mechanisms for high-risk uses, and it takes a lighter approach to lower or minimal risk systems. This particular proposal doesn't focus too much on AI and IP, but AI and IP is a key part of the ongoing debate about appropriate legal frameworks. And just as rules that take AI into account are important generally so that we get the best possible outcomes from AI, they're important specifically with respect to IP to make sure we get the outcomes that we want from our IP systems. And just as AI is going to be economically and socially disruptive, AI is going to be very disruptive to our IP systems. In some ways, just as AI has been around for a long time, the challenges AI poses to the IP system aren't new. For example, people have said they've developed computers that can make music since at least the 1960s. And in 1966, the US Register of Copyrights, Abraham Kamenstein, publicly questioned whether these works should be copyrightable and disclosed that the office had already received applications for at least partially computer-generated works, including musical compositions. If you haven't heard some of this music, I have, and I can assure you that it's terrible. But AI has come a long way since the 1960s. You can go to OpenAI's Jukebox initiative now and hear some newer examples of music made by AI that still isn't great, but it's no longer terrible. Some of it isn't half bad. This site has AI that makes music in the style of existing artists, which raises another group of interesting IP issues. But as AI music has gone from terrible to mediocre, it is worth keeping in mind that AI is only going to improve its performance. At some point, we're likely to have AI that can make music people actually want to listen to. And that's going to be incredibly disruptive, because once you have an AI that can make good music, you can have that AI make a virtually unlimited amount of it at almost no additional cost. That's going to be competition for human musicians, the way that self-driving Ubers are going to be competition for the 3% of our workforce that provides driving services. But AI won't just be replacing people. It'll be doing new and interesting things like creating personalized music for you in real time to go along with your moods, or maybe a video game that you're playing. This is an autonomous AI painting from the 1970s. And if you told me it was done by a computer, one of the great modern artists of the 20th century, or one of my toddlers, 21st century, I probably wouldn't be able to tell the difference, although that probably says more about my lack of artistic sense than anything to do with computers. As with making music, AI has gotten better at making art, maybe, but at least the art is selling for more. More headlines were made in 2018 when Christie's became the first auction house to offer a work of art created by an algorithm. And this piece here sold for $432,500. Now, exhibits filled with AI-generated artwork are no longer newsworthy. If you're looking for shocking headlines in the art world, it's probably what people are paying for NFTs, which makes me regret some of my life choices. An NFT is basically data stored on a digital ledger that can represent an item like a photograph or a piece of artwork. A number of NFTs now are AI generated. AI generated or not, people are willing to dole out large sums of money or cryptocurrency, at least for NFTs, for which they may not even own the copyright. And yes, AI making art is going to be socially and economically very disruptive, but for the lawyers in the crowd, they're going to mean a lot more business for copyright lawyers, which I think we can all agree is a positive development. Normally, when someone makes something like this AI-generated NFT you see here, the work attracts copyright protection, which protects someone else from copying or selling the work for the author's lifetime plus in the US 70 years. Well, what if that someone's an AI? At the end of 2019, the US Patent and Trademark Office put out a request for comments on AI and patents, as well as a request for comments on AI and IP more generally. It published a report summarizing some of the comments it received early last year. And these requests for comments canvassed a broad array of issues associated with AI and IP, and there's more important issues than you might think. So you saw some of this in terms of AI generating traditionally copyrightable work. Can you get a copyright for an AI generated work? Who or what would be the author? Who would own it? How long would you get a copyright for? And so forth. And whereas Sean mentioned back in the 60s, people didn't really care about this so much, in part because there wasn't such a big market for AI generated music. As that changes over the next few years, given the speed at which it is changing, this is going to become a commercially very relevant question, or a series of questions. And those same basic questions apply to AI making other sorts of intellectual property like patents, designs, and trademarks. Trademarks are an interesting area to think about AI. It took me about 30 seconds at brand.io to generate this slide with very little input from me. This could have been a book cover. It could have been a trademark for a new product based on the book if I came up with a new product. So AI can make new trademarks, but perhaps more interesting is how AI can fundamentally challenge what we think of as a trademark and how it functions. Trademarks are designed to indicate the source and origin of goods and services to consumers. But what happens when the AI is the consumer? What happens when commerce is online and AI is both the seller and the buyer? Or how does Alexa determine the source and origin of goods and services? And what sort of competing marks would Alexa find confusing or deceptive? And how do we apply infringement tests based on human consumers to AI purchasers? The United Kingdom Intellectual Property Office launched a similar consultation to the US Patent and Trademark Offices in 2020 and published their results this year. And to me, one of the most interesting results of this was how different the findings were from those of the USPTO, even with many of the same stakeholders providing submissions. Maybe part of that is that AI and attitudes toward AI are changing so rapidly that there can be a significant difference just in the course of a year. And these aren't, again, just questions about AI making new intellectual property. AI is being developed using intellectual property. AI is intellectual property, and it is directly using intellectual property. Consider Clearview's AI, which has collected and trained on more than 10 billion images from across the internet. And Clearview provides this AI to provide facial recognition technologies for law enforcement. Well, generally, copying an image constitutes copyright infringement, but what if it's being copied or used to train an AI or just to generate insights? Is that infringement? What if a bunch of machines are sending digital copies of images between each other? What if an AI is functionally infringing someone else's intellectual property, but not in a way that's directly attributable to a person? Who would be responsible for that, and on what basis? Different jurisdictions may have different answers to some of these issues. As for example, there's a very broad exception to copyright infringement in Japan for text and data mining, and a much narrower one in Europe. But a lot of this hasn't been explored, including in what situations it would be infringement for a machine to do something that would be infringement if a person did it. And just as different jurisdictions are thinking about these issues somewhat differently, that's a whole nother dimension to our discussions of AI and IP, because the intellectual property system is relatively harmonized around the world, so that a book you write in Washington is protected in France and Brazil and India. Not so clear that's the case with a book you have an AI write. WIPO, the UN agency most responsible for intellectual property, has gotten into the action by hosting a series of stakeholder discussions around AI and IP. In theory, an international treaty might come out of this, so that jurisdictions around the world can agree to a common set of rules involving AI and IP, but that's a slow process. We may have artificial general intelligence by the time we have an international treaty on AI and IP. Not oblivious to the timeframes involved, WIPO is focusing for now on proposing not substantive solutions to challenges, but in asking the right questions, getting stakeholders aligned on the right issues, starting with, for example, definitions. It's kind of remarkable that about 65 years after the term artificial intelligence was coined, there still isn't a widely accepted definition of artificial intelligence, which is a real problem if you're trying to regulate artificial intelligence and write laws designed to apply to artificial intelligence, because some of the people writing these laws are talking about different things. And if people can't agree on what artificial intelligence is, there is a tremendous amount of disparity about something like an AI-generated work, how you would define that, what that means, and what matters about it. Some of these WIPO conversations are not just talking about things like AI generating new IP or potentially infringing sorts of IP. Some of these focus back on issues people have been debating for decades, including at WIPO, things like whether you can patent software, whether you can own data, or how you would protect data. Those aren't new issues, but they are issues that are taking on a new sort of importance given the disruptive nature of artificial intelligence, given the increased value that software patents, which would be patents on artificial intelligence effectively, would have, and given the importance of data for both training artificial intelligence, for AI looking at data to generate insights, and for AI generating data. Some of these issues are more specific to AI rather than older questions like deep fakes. And for those of you who haven't been spending enough time on TikTok, there's a lot of Tom Cruise on it, kind of. At least new in terms of how convincing a video appears to be to people. It isn't new in the sense this isn't the first time the law has had to deal with technologies that involve deception and manipulation. And people are also interested in AI in administrative decisions. So AI can generate new intellectual property or be used to make people more productive at generating intellectual property. It can even generate things like patent applications. For example, there's an application called Specifio that with one patent claim will auto-generate an entire patent application, although someone is supposed to review it before it's filed. This suggests that we are about to generate a whole lot more intellectual property as a society, aided by artificial intelligence, which suggests the US Patent and Trademark Office, for example, is about to get busier, and which also suggests that AI could be both the problem and the solution to this problem, in that the Patent Office may need to start using AI itself, which it is already doing, for instance, to classify incoming patent applications. But it may not be that long before a patent application comes into the Patent Office and AI classifies it, does a first pass at a prior art search, and drafts an office action for a human examiner to review. That's going to change the process in all sorts of subtle and not so subtle ways, even if you don't have an AI replacing the person. And it's a process over which there's a lot of public concern, not really with patent prosecution, because it's hard for the public to care about patent prosecution, but certainly with AI augmenting and automating administrative and even judicial decisions. I think it is perhaps second only to killer robots as the thing people are most concerned about AI doing, in part because of a lot of concerns around impermissible biases being used by AI and people using AI in circumstances such as in helping generate bail determinations for judges in criminal hearings, where there is evidence that it may come up with different recommendations for people which correlate with their protected characteristics. I don't have answers to all of these questions, but by the time we get to Grimes, I guarantee you will have gotten answers to all these questions, which is why I'm incredibly grateful to the contributors of our new research handbook coming out next year with Edward Elgar. It's the research handbook on artificial intelligence and intellectual property, because we have a really top-notch group of scholars who have tackled many of those issues in really fascinating and insightful ways. Only some of whom were able to join us today and tomorrow, but I want to thank those joining us and all of them contributing for their generosity for sharing these insights, both in the book and over the course of this event. Professor O'Connor has promised a copy of the book to everyone attending virtually today, plus extra CEUs, so that was very exciting as well. And of course, thanks to C-IP2, I've got the branding down, for sponsoring the work and this event and for getting all of us together to have a discussion that hopefully even out of the next day or two can help change the way we think about some of these topics. For my part, there are a couple of these issues that I have a couple of thoughts about, and I wanted to start with this with a case study by Siemens that Siemens reported previously in German, but in English at the first WIPO conversation on AI and IP. The picture on the left in green is a car suspension, and the picture on the right, not in green, is an AI-generated car suspension. And this was developed at Siemens, and Siemens wanted to file for a patent on this new car suspension and found that they were unable to. And the reason they were unable to is that they went to the engineers involved in making this and said, all right, which one of you invented this? And all of the engineers said, well, not me. I didn't do anything inventive. We had an AI that helped design industrial components. We told it what we were looking for. It came out with this design that we all thought was valuable and interesting. And what did we do? That isn't just whatever you want to call it on behalf of the engineer, in terms of their moral sense of what it means to be an inventor. There are serious consequences associated with deliberately inaccurately listing yourself as an inventor on a patent application. In the United States, it can render a patent invalid or unenforceable, and it can also result in criminal sanctions. I am going to try to leave some time at the end for chat and Q&A too. I see a whole bunch of chats popped up when I said Sean was going to buy everyone a copy of the book. For the avoidance of doubt, that was a joke, but maybe, I don't know, maybe peer pressure. We can work on them. So the gist of this was that Siemens had an AI that made a new industrial component that had industrial value, but they weren't able to apply for a patent on it, or they felt they weren't able to apply for a patent on it because they thought it didn't have a human inventor. And this is really the commercial impetus and importance underlying the series of test cases I've been involved with, right? And this sort of phenomenon raises a number of questions, right? If you have an AI-generated work, and let's say that that is an AI-generated invention, an AI-generated invention that lacks a traditional human inventor, can that sort of thing get a patent? And then if it can get a patent, who or what would be the inventor in such a case? Or would there even be an inventor? And then who or what would own the patent on an AI-generated invention? Now, I've talked a bit about AI doing things, but I haven't really unpacked that statement. What does it mean to say that an AI invents, and can an AI even do that? The statement that an AI can invent is still somewhat controversial, although a lot less controversial than it was even a couple of years ago. It's not such a controversial statement with AI making works that would traditionally get copyright protection, but the bar for that activity is really low. If you point your smartphone at your monitor right now and press a button, you've got an image protected by copyright. And it's hard to claim at this stage that an AI couldn't do that sort of thing. A monkey could do it. Your photograph isn't a great work of art, probably, but copyright law doesn't care whether you're making a great work of art or art by just pressing a big red button. Both are going to be protected by copyright long after you're dead. But coming up with something patentable, really anything patentable, is a lot harder than coming up with something copyrightable. For an invention to get a patent, it has to be new, so no one can have ever publicly disclosed your invention before in all of human history. It has to be non-obvious so that a skilled person, or basically an average researcher, wouldn't have come up with it from what's already out there, and it has to be useful. Now, people very frequently use computers to create inventions, and AI inventorship isn't an issue. As I mentioned, PowerPoint helped me make this deck, but I'm not listing it as a co-author of the deck, right? For that matter, just as computers are often used in creating invention, other people are often used in creating inventions. Sometimes inventions are generated with the help of a large number of people, but only some or maybe only one of those people may be an inventor. You know, rather than asking whether we have sentient machines, right? We don't, at least in the sense of human-like sentience. You know, the question is not, did a machine wake itself up in the morning, become general artificial intelligence, and decide it was going to invent something? The answer to that is, of course, none of that stuff is happening right now, right? The question is whether or not the machine did the thing that traditionally makes someone an inventor. And there's a test for what makes someone an inventor. It's a little bit different in every jurisdiction, but in the US, the test is basically, did you conceive of the invention, which means, did you have a complete idea of the invention as it was to be applied in practice in your mind? And the right question here then is, well, it's kind of twofold, whether we have a person who meets that test for AI output and whether or not the AI meets that test. Now, most of the time, you're going to have a person who meets that test. Sometimes finding a problem to be solved can make someone an inventor, but that's not usually the case. Almost all the time, we know the problem, the solution's the hard part. So we know we'd like an antibody to treat COVID-19. We know we'd like a higher performance car suspension and so forth. It's just the getting that thing is not quite so obvious. Right? Sometimes programming an AI to solve a specific problem like that will make someone an inventor. So we have certain performance measures for a car suspension. It's well known what we want. It's a problem of design optimization or parametric optimization. I think if you build an AI specifically to design a better car suspension, you train it on existing car suspensions designs, you specify narrowly what you're looking for and so forth, there's not a lot of challenge to listing someone as an inventor. But there are ways that breaks down. First, some AI is designed by dozens or hundreds of people spread over time or space. Second, sometimes the people designing the AI aren't the people that are using it. And the people designing it don't even know specifically what it's being used to do. So sure, you might have an AI that is designed to generate new car suspensions, but you may also have an AI that's designed generally to optimize certain industrial components. If you have a team building that AI and another one using it and just putting in, this is what we'd like the component to do, and the AI spits out a new industrial component, the people who designed the AI couldn't be inventors for that new industrial component because they didn't know what it was being used for. They certainly didn't know what the ultimate invention was, much less have conceived of the ultimate invention in their minds. You know, the third way that someone can become an inventor is by recognizing the value of something. But there's a big difference in being the first person to recognize that penicillin can inhibit bacterial growth and taking an optimized design from an AI and handing it to your company patent attorney. Sometimes someone can be an inventor by recognizing AI value. For example, let's say an AI being operated by Pfizer says, here's 10 possible COVID-19 antibodies. Go test them and find the best one. Well, there I think you've clearly got a human inventor. But probably not if the AI says, with 99.99% certainty, this antibody, performs better at everything we're looking for in a monoclonal antibody to COVID than any other one in my billion antibody large library. And based on the in silico or computerized analysis you do, that's sufficient to support a patent application. Or even if the AI says, and here are the tests that you would do, to generate the data to apply for a patent application, and the results of the test are as the AI predicted. There is nothing that a person is doing there that is directly inventive with respect to the AI's output. At least some of the time, what we think about as inventive activity is being done at least functionally by the AI and not by a person. A couple of years ago, there wasn't any case law on this. There were some jurisdictions that require an inventor to be a natural person. A lot of that was by case law, for example, in the United States. Although the case law on that had nothing to do really with AI-generated inventions, it had to do with whether or not artificial inventors in the form of corporations or sovereigns or similar entities could be inventors. But companies are very different than artificial intelligence because companies literally act through human agents. And sure, it would be a lot easier for IBM if IBM could leave off inventors or list itself as an inventor on all of their patent applications, but it would deny people who have legitimately been inventors from moral acknowledgement and sometimes from economic benefits. And consistently throughout jurisdictions, courts have not been willing to acknowledge companies as inventors. But AI is different because particularly in the sorts of cases that we're looking at, an AI does not directly act through a person, and there is no person who would be being unfairly left off of an application. That isn't the law everywhere. Monaco and Cyprus, for example, which are EPO member states, European Patent Office member states, reported to the European Patent Office they didn't require an inventor to be a natural person. Israel doesn't require an inventor to be listed on a patent application, but pretty consistently, that is the case. And there are some laws that explicitly say in some jurisdictions an inventor has to be a natural person. But again, never with the prospect of an AI making things in mind, just with the assumption that people are the thing that invents. There was more law, right? And there was no case on this anywhere. There was more law, though, about AI-generated works and copyright. The UK was the first country to explicitly provide copyright protection for so-called computer-generated works, and this was back in 1988. And it remains only one of a handful of countries worldwide that do so. Some other Commonwealth jurisdictions like India and Australia follow the lead of the UK in this, and Ireland, but it is the only EU member state that explicitly protects computer-generated works. Those are defined as works generated by an AI such that there is no, or a human author cannot be identified. In those cases, the producer of the work, which is like a film producer, the person who undertakes to have the work created, is legally deemed or fictionalized to be the author and owns the copyright. And of course, well, you could base the copyright on that person's lifetime. Troubling to base copyright on the life of a machine because machines don't die and don't live in the first place. But those works get shortened periods of statutory protection, namely 50 years from the date they are created. There's only ever been one case that considered this law in 2006, which involved competing video game manufacturers of pool games. And even then, it wasn't really considered because no one was debating that there was a copyright in the underlying work. A few reasons that might be: one is, unlike the United States, you can't register copyright in the United Kingdom. And as with most sorts of intellectual property, it's fairly rare that you actually get an infringement lawsuit out of a piece of this. The US, by contrast, has a Copyright Office policy from 1973 that prohibits non-human authorship. Computer-generated works automatically enter the public domain and cannot receive copyright protection. So if you're working with a computer program that autonomously makes a picture, a song, or a video that you think has commercial value, it's awfully tempting to take credit for that work, and the machine is unlikely to protest. The Copyright Office is citing to the 1886 case of Burrow-Giles v. Cerrone in support of this policy, which is a very famous Supreme Court case. It involved a photographer, Napoleon Cerrone, who sued the Burrow-Giles Lithographic Company for copyright infringement of this famous photograph of Oscar Wilde. And the company alleged that the photographer could not be the photograph's author because a photograph is just a mechanical reproduction of a natural phenomenon. But the court held that any form by which the ideas in the mind of the author are given visible expression is eligible for copyright protection. This case thus explicitly dealt with whether using a machine would negate human authorship and implicitly with whether a camera could be an author. But the Copyright Office has interpreted this case to mean that copyright requires ideas and mental products, which it thinks machines lack, and monkeys. That Copyright Office policy was almost challenged in court last decade as a result of the monkey selfie photographs. This was a series of pictures that a crested macaque named Naruto took of itself in 2011 using photographic equipment belonging to the UK nature photographer David Slater. There were a couple different versions of what happened. In one, he left the camera lying around and the monkey took its own photograph. In another, he carefully observed the monkeys and staged things so the monkey would take its own photograph. But this monkey, Naruto, took its own photograph. The photograph ended up having commercial value because people thought it was cute or entertaining. Incidentally, this is not a happy monkey. Macaques smile as a display of aggression. So Naruto is responding to his own reflection in the camera and wanting to intimidate that monkey. But in any case, people started using this photograph without Mr. Slater's permission. He accused them of copyright infringement. And this was interesting enough to people that the Copyright Office amended their human authorship requirements in 2012 or 14 and explicitly listed that photographs taken by monkeys wouldn't qualify for protection. That seemed to resolve the issue until PETA sued in California federal court, alleging that the monkey was the owner of the photographs and they were going to assist the monkey with bringing the lawsuit, and they sued David Slater for copyright infringement. That case was ultimately dismissed in the Ninth Circuit, but it was dismissed on the basis of standing. The Ninth Circuit said, unless the Copyright Act very clearly tells us that non-human animals have a right to sue, we're not going to let them bring lawsuits. And so as a result, this policy has never been challenged. So how does this sort of thing work in the patent context? Well, perhaps like the Copyright Office says, machines lack minds and can't conceive of things. So maybe if you don't have a person who qualifies as an inventor, you can't get a patent on something. But there are reasons to think that that isn't a good approach. Particularly the primary purpose of the patent system is to encourage the production of socially valuable innovation. And it does that by giving people an additional financial incentive to invent things, to disclose things, and to commercialize things. Historically, some academics have thought, well, machines don't care about patents, so why would you possibly want to patent an AI-generated invention? And of course, it's true, machines don't care about patents. But companies like Siemens, IBM, and Novartis care about patents. And if we are going to be moving from a paradigm of research and development where we want to directly incentivize people to invent to one in which we want to incentivize people to build machines that will invent, then this is a very valuable sort of activity to be promoting through the patent system. We filed in 2018 2 patents for 2 AI-generated inventions. One was a beverage container based on fractal geometry like a snail shell, and one was a flashing light beacon that could attract human or AI attention in an emergency. We filed these in the United Kingdom and in Europe because you do not in those jurisdictions have to disclose an inventor for 18 months. And these applications went through substantive review, so they were found to be new, non-obvious, and useful at the preliminary stage of analysis. But generally speaking, if I slapped my name on those patents, no one would have questioned it twice and we'd have issued patents. After that examination was complete, we updated the inventorship to note that there was no human inventor and that the AI had functionally invented these patents. And we then filed them in 15 additional jurisdictions. We did this because the AI is listed as the inventor because it functionally invented. And this isn't to give the AI credit, but it is to inform the public that this is an AI-generated invention and to keep someone from taking credit for work they haven't done. So if I could license Dabus, which is the AI we used in our case, and have it invent 10,000 things and list myself as an inventor on all of them, that would really change the meaning of what it is to be a human inventor. And it would take away from people who had genuinely expressed ingenuity rather than simply asking a machine to solve a problem for them. Of course, it has never been our position or anyone's position that the AI should own a patent. It couldn't legally because it doesn't have legal personality, but more importantly, it wouldn't care about getting a patent. It couldn't properly exploit a patent. It wouldn't make a lot of sense for all sorts of reasons. So this really isn't a case about machine rights. Now, it could be that there is some reason to give a machine some sort of right in the future. It's not that strange a concept when you think that artificial persons have all sorts of rights. And for that matter, most patents are owned by artificial persons. For example, you could have a self-driving car that has some limited form of legal personality so that it could own security or an insurance policy if it causes an accident. But there's really no way that I can think of where it isn't just a lot better to have the manufacturer liable for the machine's accident. So, certainly not on moral grounds are we advocating for any kind of machine right. And on practical and legal grounds, there's no room for that either. The owner of the thing would be the person who owns the AI. Now, there isn't a statute that requires that, but there are various common law rules of property ownership that suggest that's the right outcome. For example, if I own a 3D printer and I have it make a 3D beverage container, absent some compelling third-party claim, I own that beverage container and no one would really think otherwise of it, right? That is a common law rule of property, sometimes called accession, which relates to someone owning a piece of property by virtue of owning some other piece of property. For example, you own a cow and it has a calf, you own the calf. You own a fruit tree, it makes fruit, you own the fruit. Well, if I own a 3D printer and it makes a beverage container, I own that. And if I own an AI and it makes some patentable invention, I should own that as well. Absent some interesting potential third-party claims where you have many people involved in owning, operating, and developing an AI, but we'll have to save that for another lecture. Right. And so if Dr. Thaler does in fact get a patent on these inventions, it creates this new incentive to be having machines out there generating socially valuable innovation, which, much like self-driving cars, is useful now, but it's going to be a lot more useful in the future. And if we have a few minutes, I'll just talk briefly about how an AI can make this sort of thing. This was how the predecessor to DABUS functioned in the early 1990s. You have at least two networks, neural networks. You train one neural network on data, and then it corrupts the data it has been exposed to, and this generates new output it's never seen before. And you have a second network, and if you tell it what you're looking for, it can evaluate the data coming out of the first network and say, this is new, and this is what you're looking for. For example, if it's a car suspension, and you're looking for one that can, I don't know much about car suspensions, but perform better than the thing that you're looking for. Modernly, this neural network now has thousands of separate neural networks, each of which encodes for a concept. It is trained by a person to form basic concepts. And then in unsupervised runnings, it will combine basic concepts into complex ones and identify the value of concepts. And this did, in at least two instances, come up with essentially patent claims around which we built these applications. In July of this year, we received our first patent in South Africa. The AI DABUS is listed as the inventor, and the patent belongs to Dr. Thaler, who is the AI's owner. Now, South Africa is a little unusual in that they do not do substantive examinations of patents. So South Africa doesn't look at whether inventions are new, non-obvious, and useful before issuing them. For long, complex reasons. But these applications were already reviewed for those things by the UK and EPO, and South Africa does do formalities, diligence. And so, in every jurisdiction where these have been rejected, it has been on a formalities basis. Not all has gone as well as South Africa. We have filed these now, I mentioned, in 17 jurisdictions in total. It is pending in 16 jurisdictions. It has been denied on a formalities basis from the US, the UK, Europe, and Australia on the basis that these applications did not appropriately designate a human inventor. 3 days after this South African decision, Justice Beach in the Federal Court of Australia issued a 41-page reasoned decision essentially finding the same thing, that there was no prohibition on an AI being an inventor under patent law, and that at least in our case, as the owner of the AI, we had the most compelling claim of entitlement to it. Not to give the sense that everyone's coming along to this perspective, we recently had our case dismissed by Judge Brinkema in the Eastern District of Virginia. This is now on appeal to the Federal Circuit. And in that case, the judge essentially found that terms such as individual used in the Patent Act referred to natural persons. It was our argument that, that a narrow textualist approach was not appropriate in this context, that a more purposive interpretatory approach was necessary, that there had been no intent to deny protection of AI-generated works, and that these already are accommodated by US patent law. But we'll see how that plays out. The most recent update was, good thing the date's up there, last September, we had our appeal dismissed by the UK Court of Appeal. This is now on appeal to the Supreme Court, which is discretionary. But this case did split. Lord Justice Burse, who was the judge behind the Huawei and the Unwired Planet decisions, did hold in our favor that there should be no prohibition on granting a patent for this sort of thing. He thought that the UK IPO had no obligation to list any sort of inventor, and that the inventorship could simply be listed blank if there wasn't a natural person. And we also have a hearing coming up before the European Patent Office in December, where they tentatively suggested the same solution, that if you don't have a human inventor, you can still get a patent. You just don't have any kind of inventor. Those are courts looking at this. There has also been some legislative interest. So India recently completed a parliamentary consultation, which held that the law should be explicitly amended to be clear that AI-generated work should be eligible for all sorts of intellectual property protection, including patents. After that, the president of South Korea announced that he believed AI-generated inventions should be protected, and patent law needed to accommodate this. That's just one of the issues that I think are very exciting with AI-generated inventions. These entitlement, ownership, subsistence issues associated with that. We did these test cases for several reasons. A real lack of guidance for industry on what the law was in this place, a lot of assumptions, but really not much actual law or interpretation from courts, to encourage these discussions we have about the role of AI and R&D and how we want to encourage or disencourage people to do that sort of thing, and then to promote the use of AI, through allowing patents on this sort of thing. And then perhaps most of all, because it's hard being a patent attorney, and there was a hope that this case would make us marginally more interesting than tax attorneys. And I think that it has largely done that. So we're fairly pleased with what's happened so far, and we're looking forward to seeing how the rest of it plays out. And just to give a couple other thoughts on how this sort of phenomenon is going to really radically change intellectual property law, I mentioned that one of the ways you get a patent is, or one of the ways an invention gets a patent is it has to be non-obvious. So an average researcher can't find an invention obvious. And that's basically from the perspective of an average researcher. I chose a picture of London commuters pre-COVID to represent an average researcher. This really is how unhappy everyone looks in London commuting. But that's going to change with AI, because average researchers are already using AI pretty extensively, and AI makes an average researcher more sophisticated. It does that at least two ways. One is it's unrealistic to expect a person sitting in their garage with books to know everything in every field. But with the help of AI, even if you're looking for a new antibody, the AI can help you find prior art that may be useful in all sorts of fields. It also gives you essentially, even without the AI doing anything inventive, some superhuman problem-solving capabilities, for example, recognizing patterns in large data sets. And so in some fields more than others, the skilled person may be a skilled person using AI. And that's really going to have an impact on things. If you think about monoclonal antibodies, which we talked about a bit earlier, these are all of the best-selling blockbuster biological drugs are monoclonal antibodies. These are made by your body to target pathogens, and they can be artificially manufactured to target all sorts of things. And one of the interesting things about this from a computational perspective is there's a limited number of antibodies that could exist, trillions or quadrillions or whatever, right? More than enough to keep every human researcher occupied for as long as you could think of, but maybe not so hard for an AI like DeepMind to sequence every possible antibody publish those online, and you may not be able to get patents if it's an anticipatory disclosure or an enabling disclosure on antibody structure anymore, which is essentially the foundation of all patent portfolios for biological drugs. In fact, AI is already predicting all sorts of things based on antibody structure, like binding to various things, to drug-drug interactions. It's not too hard to imagine that in the not too distant future, an AI will not only sequence every conceivable antibody, but could just tell you what all of them could be used to do. And that's going to really change how human researchers come up with inventions for monoclonal antibodies. And it might also cure cancer. And if you are a believer in this concept of the technological singularity, or that we are going to develop an AI that will be able to do any intellectual task a person could do, and the first thing you'd ask it to do would be to improve its own programming to the point where it eventually becomes artificial superintelligence and is so sophisticated we can't even conceive of the sorts of things it will do. Well, once you have artificial superintelligence helping skilled people or stepping into the shoes of skilled people, everything is going to be obvious to a superintelligent computer, and you're not going to get patents anymore. Although that may be okay because the cost of innovation then will be essentially nothing. And to the extent that we have other benefits we get from patents, like protecting commercialization of drugs, we may have to shift to some other sorts of protection mechanisms. I didn't leave that much time for questions, but I'll just leave you with a few thoughts. One is, even for those of you not terribly engaged in AI and IP, I think AI and IP has all sorts of valuable things to think about for IP more generally. For example, we think that patents and copyright both protect economic and moral rights. So, it protects an author's right to be acknowledged, and it protects, effectively a publisher going out and printing a bunch of books. Well, if you no longer have a person in that picture and you no longer have moral rights, do we still want to have copyright the same way or doing the same sorts of things? Does this really all collapse to investment in economics, or do we want to have laws just for people? And I tend to think not. That would be a protectionist measure and would lead to all sorts of negative outcomes, but it really does challenge some of the very basic principles of intellectual property law. And more broadly than that, I think that, treating AI behavior and human behavior differently end up having all sorts of problematic outcomes. You see this in intellectual property, where you see we can have people inventing things or humans inventing things, and that this should just be left to the market to decide which is most efficient. Because if you tell GSK or Johnson & Johnson that you can't use an AI to make a drug, at least not if you want a patent on that drug, then it tells industry, well, we're just going to have to use people. But that's a real problem if it turns out that machines can do a better job than people at certain sorts of activities, and if these are socially valuable activities and they're activities that you really want to promote. Right? The same sort of problem plays out in other areas of the law, like AI doing productive labor, but being subject to very different tax consequences than having people do things, or AI and people driving cars, but being subject to very different liability regimes. Essentially, AI and people are doing the same sorts of things right now, different laws apply, and this ends up having all sorts of socially harmful consequences. And in this earlier book, I went through some of those examples and talked about why we would all be better off and why people would be better off if the law did less to distinguish between AI and human behavior. AlphaGo beating Kujier was a big deal, not quite as much attention as an IBM AI Deep Blue got for beating Garry Kasparov in 1997. When Kasparov recovered his composure, he had a pretty bright idea. And the idea was, okay, so an AI can always beat a person at chess. But I bet that actually an AI and a person could do a better job playing together than they could independently, because an AI can crunch 300 million moves in a second, but a human grandmaster can think very far ahead. And he was right. The following year, he won the first AI human centaur chess tournament where an AI and a person play together. Not surprisingly, an AI and a person beat a person, but they also beat an AI because AI and people are strong in different dimensions. And I think that this points to a near future in which we're going to get optimal sorts of outcomes by combining AI and human behavior. At least Kasparov was right to a point, because the same year that DeepMind beat the world's champion, the chess engine Cryptic beat the world's leading human plus AI team. At some point, the human grandmasters just got in the way. All right. Thank you very much for your time and attention. Let me try and look over some of the Q&A and questions. Okay, the questions mainly had to do with people being able to hear me. So let's see. We have a question here from the requirements for IP protection were drafted having in mind people, not AI. If we are granting the status of authors and inventors to AI, should we apply the same requirements or adjust them to the specifics of AI? For example, the non-obviousness requirement for patents. And I think that that question came in a bit earlier, but we are better off not having two different standards for this sorts of thing. If there is an AI system that only, I'm running out of pharmaceutical companies to name, but Amgen has, that is dramatically more effective at finding new drug treatments or repurposing existing drug treatments, that isn't a sort of activity that is widespread and shared by standard researchers. And allowing Amgen to protect that activity encourages these companies to be investing in building and trying to outperform industry standards at generating innovation. And that's a valuable sort of activity. You know, similarly, I wouldn't be in favor of having a separate lower standard for human inventors, because if we get to a point in time where AI can invent drugs with trivial ease, we really don't want to be creating blockages with people engaging in activities that they are really better off not doing. For the foreseeable future, even if AIs take over finding new treatments for monoclonal antibodies, there's going to be plenty for human scientists to do in all other sorts of areas. And if we ever really get to a point where AI can do everything better than we can, you know, for example, instead of just diagnosing macular edema and diabetic retinopathy, if an AI is objectively much more effective at diagnosing and treating disease and even doing operations, then I think it would be really problematic to have people in that role, you know, not only because they would be providing a service that would be, you know, much less optimal than something someone else could be getting, but even if someone was doing it to find some sort of professional fulfillment, you know, we would only be creating protectionist jobs for people, and you would be doing pointless sorts of labor. You know, if we end up in a world where AI can really do everything for us, I think the bigger problem is making sure that 100% of that wealth doesn't just go to Jeff Bezos, and making sure that we're all able to share in the benefits of automation. And I am sure people will find something useful to do with their days, whether it's deepening their personal connections, engaging in self-improvement, or just playing with virtual reality all day. All right, let's see here. And I think that I kind of touched on some of these. Let me see if I can just say one more here. My question is, how would listing the AI as the inventor patent owner help with the progress of science? Wouldn't incentivizing the innovations being conducted be achieved through other means, such as granting rights to the owner programmer of the AI and not naming an inventor? Well, yes. So no one is saying that an AI would own a patent. The owner of the AI would own the patents on the AI output. The AI would be listed as the inventor because it functionally invented something, to inform the public of how it was invented, to keep someone from taking credit for work they haven't done, and for providing acknowledgement for the people who program that AI. You know, the same way that when my PhD students go out and publish things, I take some credit for that, but I don't list myself as a co-author on their publications, or at least I'd be a pretty bad PhD supervisor in the UK if I did that. Different systems having different rules about that. All right, I think that, I think with 2 minutes left, unless someone has a verbal question, that pretty much covers what we've got.
All right. Well, I'd like to thank Dr. Abbott. Ryan, that was a fantastic presentation. That was exactly as we hoped it would be. And please be assured that I think it was only one or two people who had some audio issues. So don't come away from this thinking that, you know, none of the a couple hundred people were actually listening to you. And we'll make recordings available to the few folks who were not able to hear it. I also want to point out that Ryan is going to invite us all over to his beach house there for drinks and free copies of the books after the conference is over. So just contact him and see exactly where that excellent beach house is located. I also want to point out that we failed in our introduction to point out it's really important to know that Ryan is both a JD and an MD. And so he comes at this from both the medical perspective, really thinking about neural networks, how it connects with the human brain, and then also from the JD perspective. So on that now, I want to again, and this is the terrible thing about online, we can all virtually clap, but really, I think it would be an outstanding response if you were in the room. We really appreciate what you've done for us now. And so we want to start changing over now to our next panel. So Dr. Abbott, again, thank you very much for getting this conference off to an excellent start.
Thanks so much, Sean.